So it's now my pleasure to introduce our final speaker, also a former president of our club, Lord Stewart, Angus Stewart. So Angus is a retired Court of Session and High Court judge. He practiced as an advocate before his appointment as a judge. He served as keeper of the Advocates' Library from 1995 until 2002. And in that role, he was the inaugural chair of the Faculty of Advocates Abbotsford Library project. Angus's topic today is, I would fight knee-deep in blood ere it came to that. Does this journal entry for 9th of June 1826 give a clue as to why Scott changed the setting of the Bride of Lammermoor from before to after the union of Scotland with England? So I'll now hand over to Angus. Thank you.
Thank you, Madam Chair. This contribution raises a question, as Madeleine mentioned, about a journal entry of the 9th of June, 1826. And the question is, does the entry give a clue as to why Scott changed the setting of the Bride of Lammermoor from before to after the union, less veiled on contemporary events? It can be both, of course. In the case of Sir Walter Scott, I suggest we can be reasonably satisfied that certain passages in his fiction reflect preoccupations of the author's own day. The passages I have in mind on today's occasion are in the Bride of Lammermoor, not the original text of 1819, but the revised Magnum edition text of 1830. There is a clue, an unmistakable clue, I suggest, once we know the background, in the journal entry of 9th of June, 1826. Here is the journal entry, quote, "One effect of running cases fast through the courts below is that they go by scores to appeal, and Lord Gifford, that's Gifford spelt Gifford, not Gifford as we should say it, an Englishman, Lord Chief Justice and then Master of the Rolls, the first Baron Gifford, who in the Lord Chancellor's absence chaired the Appellate Committee of the House of Lords." My father warned me, by the way, never to trust a man who can't pronounce his own name. Anyway, going back to Lord Gifford, cases go by scores to appeal, and Lord Gifford has hitherto decided them with so much rapidity as to give great satisfaction. The consequence will in time be that the Scottish Supreme Court, that's the inner house of the Court of Session, will be in effect situated in London. Then down fall as national objects of respect and veneration the Scottish bench, the Scottish bar, the Scottish law herself, and there is the end of an old sang, where I, as I have been, I would fight knee-deep in blood ere it came to that. But it is a catastrophe which the great course of events brings daily nearer. That is the journal entry. Now, I'm sure, Madam Chair, the reference is familiar, the end of an old song, words spoken by Scotland's Lord Chancellor Seafield on the sealing of the union with England. The independence of the Scottish courts and Scots law was meant to be preserved by the Act of Union, but Scott's journal entry foresees the disappearance of that legal vestige of Scotland's nationhood. So what prompted the journal outburst? I have to mention two preliminaries. First, I acknowledge the inspiration I've derived from Eric Anderson's edition of the journal, of course, from Ian Gordon Brown, he's with us today, from Professors John Cairns, Jane Milgate, and Peter Garside, Peter being this year's club president. Secondly, in what follows, I have sometimes, by omitting wordage superfluous to my purpose, compressed or paraphrased quotations from Scott's writing. So, to begin at the beginning, the Bride of Lammermoor tells of the tragic love affair between the dispossessed royalist, Edgar, Master of Ravenswood, and Lucy, daughter of the Arrivist lawyer politician, the Lord Keeper, Sir William Ashton, a Low Church man. The castle and lands of Ravenswood have, by questionable means, in Scotland's Court of Session, been forfeited to the Lord Keeper. The original 1819 text of the Bride places the action before the Act of Union of 1707. The text of the Magnum edition of 1830 puts the action afterwards. The alteration means that Ravenswood's threatened legal challenge to Ashwood's dubious appropriation of the Ravenswood estate, a, quote, protestation, as it was called to the Scottish Parliament, for, quote, remede of law, becomes, after 1707, a threatened appeal to the British House of Peers, in other words, the House of Lords. The change is illustrated in the interleaved version, a binding with blank pages for manuscript changes, which shows Scott's abrupt manuscript emendations of the previously printed text. On screen now, I hope, for you. Can we see this page from the interleaved version?
Yes.
Yes. Thank you. The passage that I previously read, quote, if the Scottish Parliament should be disposed, let's look at the next bit. If the Scottish Parliament should be disposed to act upon the protestation of the Master of Ravenswood for remede of law, has been revised to read. Part of the emendation is on the facing page that we saw, has been revised to read, if the English House of Lords should be disposed to act on an appeal from the Master of Ravenswood. Now, this redating allows Lord Keeper Ashton's circle to allows Scott to use the fictional anxieties of Lord Keeper Ashton's circle as a vehicle for actual concerns about appeals to the House of Lords in the novelist's own day. In the Magnum edition, Scott suggests that the earlier text did not sufficiently bring out the contrast between the black letter justice of the Court of Session and parliamentary equity. The contrast and the dramatic effect are heightened by moving the appeal to a distant forum, the House of Lords in London, which, insofar as conversant with the law of Scotland, is possibly contemptuous of it, and where the outcome is beyond the Lord Keeper's provincial influence. And there is an added dimension, already alluded to, the threat to Scotland's national identity as manifested in the separate legal system. Now, a critical difference between protestations for remede and appeals is that the former did not automatically suspend enforcement of the court judgment complained of, while the latter did for a century from and after the Greenshields case in 1711. The situation is shown graphically on the screen. As a result, appeals to the Lords multiplied by 1806. 1806 is here. Wait a moment. Scotland at that point is the top line on this chart of Scotch appeals. By 1806, the situation had reached crisis point, not at that stage for the substantive law of Scotland. Decisions of the House of Lords were generally ignored north of the border as substantive law precedents, but for the administration of British justice, 4 out of 5 Lords' appeals came from Scotland, and there were 200 Scotch appeals in the backlog. There followed more than 20 years of initiatives to curtail appeals from the session to London. In the century after the Union, the impact of decisions by the House of Lords on the substance of Scots law was negligible. Law reporting is how knowledge of case law precedent is disseminated, and incredibly, there was no published collection of Scotch, as they were called, appeal reports until 100 years after the Union. That arrived in David Robertson's reports of cases on appeal from Scotland, decided in the House of Peers, from the Union in 1707 to the commencement of the reign of George II, and that was in 1727. So a very partial reporting at that stage of House of Lords decisions. The preface to Robertson's reports implies that decisions of the Court of Session, which had been reversed in London, continued to be regarded by Scots jurists as authoritative in point of law. But all that was about to change. Scott had been gazetted Joint Principal Clerk of Session in Dalrymple's office on the 8th of March 1806, so not a lawyer politician in the Sir William Ashton mould, but nonetheless during the initial phase of reform in the first rank of the supporting caste as a functionary and as a polemicist. The Faculty of Advocates meetings of 1807, a leading opponent of Lord Grenville's court reform bill, that was a Whig bill, probably responsible too for getting the anti-bill speeches published. Secretary of the Judge's delegation to the House of Lords during the Court of Session spring recess in 1807, clerk to the Royal Commission for inquiring into the administration of justice in Scotland, established under Lord Chancellor Eldon's watered-down Tory Judicature Act of 1808, clerking the commissioners' meetings in Edinburgh and London through 1809 and 1810, the author of the anonymous article View of the Changes Proposed and Adopted in the Administration of Justice in Scotland in his own Edinburgh Review, published in 1810. Scott is revealed as someone with a serious interest, both philosophical and pragmatic, in the workings of the law and the ways it shapes and is shaped by society. The immediate relevance of the 1810 article, an excerpt of which is now on screen, is Scott's repetition of the critique which he had first offered in 1807, namely that the remedy for the perceived mischief of too many Scotch appeals lay with the House of Lords and not in changes to the Court of Session. And so it proved from the 1820s with progressive professionalisation of appellate business in the Lords, taking the business into the hands of legally qualified peers. The landmark reforms of the Court of Session, introduced by the respectful and lenient hand of the Tory Lord Chancellor Eldon from 1808, did not apparently cause Scott anxiety for the future of the substance of Scots law. These reforms were structural. They divided the 15-judge Court of Session, Scotland's Supreme Court, into two divisions. The first division of the Inner House, chaired by the Lord President, and the second division of the Inner House, chaired by the Lord Justice Clerk. A subsequent phase of reform, which focused on procedures, was different. It saw Scott fulminating from the sidelines about, quote, the interference of these Englishmen with their periwigs and their parchment bags. That was in 1823, when the Royal Commission on the Form of Process, i.e. court procedure, and the course of appeals to the House of Lords was set up. At the same time, another historical romance was in preparation by Scott, the novel to be published in the following year as Red Gauntlet in 1824, which no coincidence, I suggest, the dyed-in-the-wool Jacobite Hugh Red Gauntlet mocks as, quote, mongrel things, those Scottish advocates who, quote, must creep to learn the ultimate decision of their causes to the bar of a foreign court, instead of pleading before the independent and august parliament of their own native kingdom, close quotes. Mark the words foreign court. The Royal Commission's proposals were put into effect by the Judicature Act of 1825 with related rules of court, and poor Sir Walter officiated at the Saturday sitting of the full court, both divisions sitting together, on 12th November 1825, when the new rules, for which he had no taste, were appointed by the Lord President to be inscribed by him in the books of Sederunt. Scott sounded the alarm at the beginning of 1826 in the pseudonymous letters of Malachi Malacrowther. The polemic was published in defence of the right of Scotch banks to issue their own currency, but Scott illustrated his argument with reference to what was already happening in the legal sphere. He deprecated the error of judging another country's laws without being aware of the whole context, and he wrote, it would be no reason for planting, here we come back to trees again, we no reason for planting mulberry trees in Scotland that they luxuriate in the south of England. Of the recent procedural reforms, he wrote in these pamphlets, I beg therefore to be considered as not speaking of the alterations themselves, but of the apparent hostility towards our municipal meaning national, our municipal institutions as repeatedly manifested in the course of late proceedings, tending to force and wrench them into a similarity with those of England. What I do complain of is the general spirit of slight and dislike manifested to our national establishments by those of the sister country, close quotes. And Scott complained also of the, quote, jealousy of, quote, hasty and imperfectly informed English judges who have, quote, shown themselves so anxious to revolutionize the Scottish legal system. And think it's quite possible that in writing this, our author had in mind Lord Gifford, now on screen. One particular litigation conducted under the new dispensation and clerked by Scott in the Inner House, in the first division of the Inner House, was for Scott the most disturbing portent of things to come. It took less than a year under the new procedures for the cause in question to go through the first instance in the Inner House and the appeal to the first division of the first instance in the Outer House and the appeal to the first division of the Inner House, and to reach final determination in the Lords at London. The Lords declined to affirm the decision of the to consult with the second division judges as to whether the English rule, the equitable English rule in the case of Sitwell and Bernard, should become part of Scots law. The first division, let it be said, had already determined unanimously that, quote, to apply the English doctrine would be setting up a principle of equity against the intention of the testator, namely the person who had written the will. The decision of the Lords was pronounced on the 26th of May, 1826. Within a week, the news was in Edinburgh, and then Scott made the entry in his journal about the forthcoming catastrophe for the law of Scotland. I think it's worth reminding ourselves of something already been mentioned, that at this point in time, Scott was grieving for the death of his wife. Before I answer the question posed at the outset, let me mention a curious thread running through Scott's fictional tale of Ravenswood and Ashton. The thread is the Dalrymple family. The origin of the Bride's story was a real-life tragedy in the Dalrymple family in 1669. The Whiggish Sir James Dalrymple became president of the Court of Session and was ennobled as Viscount Stair. The character of Sir William Ashton, the bride's father in the novel, is said to have been based, though Scott denied it, at least in part, on the character of Viscount Stair. Quote, brilliant pliability in an age of trimming. The Lord President's son was made the Earl of Stair, and it was the judgment of the House of Lords in the case, John Dalrymple, 7th Earl of Stair, against trustees John Dalrymple, 6th Earl of Stair, that provoked the general outburst. When Scott came to review the Lammermoor text for the Magnum edition, he was bound to have had in mind the recent Earl of Stair appeal to the House of Lords. Indeed, in the very first sentence of the Magnum introduction, Scott alludes to the 7th Earl, John William Henry Dalrymple, who succeeded to the earldom on the death of his cousin in 1821. I don't want to put it too strongly, but let me ask this question. Is it possible that Scott felt a sort of sense of betrayal? In the 1819 edition, Scott had concealed the origin of the Lammermoor story out of sensitivity for this John William Henry Dalrymple and his scandalous matrimonial difficulties. And yet here was the same man, now an Earl of Stair, pressing on with his appeals to the House of Lords, to the detriment of Scots law, as it were, when he could well afford to compromise. Let's just have a picture of Scott at this point in time. This is a portrait of Scott sitting as Clerk of Court in 1829. I believe the chair he's sitting on is the chair which is still in the possession of the Faculty of Advocates. And this was at the time when the Magnum edition of the Bride was in preparation. As Scott feared, things did get worse. In the Stair litigation, the judges of the First Division duly consulted their brethren, the judges of the Second Division, and sent back exactly the same answer to the House of Lords, who would have none of it, and directed their lordships in Edinburgh to apply the law of England. That was in June 1827, and the forward policy of the House of Lords on Scotch appeals continued. And so Scott came to change the historical setting of the Bride of Lammermoor. The 1830 edition has the following description of the attitude of the Ashton Circle to an appeal to the House of Lords. Quote, "A degradation of Scotland, the decisions of whose learned judges are thus subjected to the review of a court composed indeed of men who might be supposed specially to hold in contempt the law of Scotland." And thus, added to Ashton's anxiety about his personal fortunes, was a professed anxiety about what would happen to the law of Scotland. Quote, "If the law of Scotland, as declared in her Supreme Courts, were to undergo a reversal in the House of Lords, the evils which would thence arise to the public would inflict a greater wound upon his, i.e. Lord Keeper Ashton's, would inflict a greater wound upon his heart than any loss he might himself sustain." Close quotes. He, Lord Keeper Ashton, unlike, let me interject, the 7th Earl of Stair, would be prepared to compromise the dispute rather than that, quote, "the law of Scotland should sustain a severe wound in the case of the barony of Ravenswood through the intervention of what Ashton said he must term a foreign court of appeal." There we have it again, phrase, foreign court. So back to the question posed in the title. Does the journal entry of the 9th of June 1826 give a clue as to why Scott changed the setting of the Bride of Lammermoor from before to after the union of Scotland with England? And the answer, I suggest, Madam Chair, is yes. Thank you.
Well, thank you very much indeed, Angus. So that concludes the presentations from our three speakers, and the floor is now open for any questions or comments. I think if you're able to raise your hand if you'd like to ask a question or make a comment, Lee can then unmute you. Thanks.
Could I ask whether the various things that Angus mentioned that led to the text being changed, whether they were things that people in general in Edinburgh or Scotland would know about, or were they really rather just people who are connected with the law would have been aware of? Were they matters of contention on a wider scheme?
Why, on air, I can't answer that question. What I can say is that within the legal profession, certainly, there was a knowledge of what change had been made in 1707, and an understanding that Scots law really hadn't been innovated upon by the House of Lords for 100 years after the Union. I would have to go into the matter much more deeply to find out whether popular sentiment was disturbed by these developments. It has been a matter of comment since Scott's time. And I think the high watermark of the imposition of English ideas in the legal sphere came in 1854 with a case called the Barton's Hill Coal Company case, where I think it was Lord Justice Chelmsford said something like, if this be the law of England, is there any reason for thinking it should not also be the law of Scotland? But no, I can't answer your question directly, Alan.
Thank you.
Yes, it doesn't look as if we've any other questions or comments. I was just going to comment, Ali, that it looks, you mentioned, that we're just at the end of Mental Health Awareness Week, and I think there's quite a lot in the public field these days, letting us know that walks in nature and getting into nature can be a great benefit to mental health issues. So Scott really seems to be quite ahead of his time in identifying that.
Yes, that's what's interesting, is that now that seems almost commonplace, but to find Scott writing about that so much in the journal and recognising that, and recognising that it's not just walking; it's walking in nature, and for Scott particularly among trees, I think that can do you good, and it's really nice to see Scott sort of anticipating that. It's just another sense in which we can see Scott being ahead of his time, which is good.
Thanks. Well, yes, I think in the absence of any other questions, we shall conclude our colloquium. And may I just thank all three of our speakers for very different contributions, different topics, but all extremely interesting and fascinating. And